Is abortion constitutionally protected? In 1973, the United States Supreme Court argued yes. That year, the court handed down its landmark decision in Roe v. Wade, where the justices concluded that the Constitution protected a woman's right to obtain an abortion. The main reason they provided comes from, quote, the lessons and examples from medical and legal history. What are the examples from medical and legal history the court is referring to? The answer to that question can be found in Section 8 of the court's decision. It is in this section that the court appeals to previous decisions which protect a right to personal privacy. Among those decisions are the following: Pierce v. Society of Sisters, which protected the right to religious education; Meyer v. Nebraska, the right to learn German; Skinner v. Oklahoma, the right not to be sterilized; Griswold v. Connecticut, the right to obtain contraception; and Loving v. Virginia, the right to interracial marriage. These examples from legal history set the precedent which grounded the court's decision in Roe v. Wade. So, where in the Constitution do we find the right to privacy which protects these personal liberties? The Roe Court appealed to the Liberty Clause of the 14th Amendment. The 14th Amendment states, "No state shall deprive any person of life, liberty, or property without the due process of law." However, the Liberty Clause here does not protect every action. Certainly, you don't have a constitutionally protected right to steal your neighbor's car or damage another person's property. So, what liberties does the 14th Amendment protect? The court writes that the 14th Amendment protects private actions which are fundamental to the concept of, quote, ordered liberty. Sounds fancy, but you can think about it like this.
The Roe Court seems to assume that an action is an expression of ordered liberty if it does not infringe upon the rights of others. So you don't have the freedom to steal my hat because that would infringe upon my property rights. Likewise, censoring a preacher is not an expression of ordered liberty because that would infringe upon his rights to free speech. In other words, the Roe Court seems to assume that actions that do not infringe upon the rights of others are protected by the 14th Amendment.
As a result, the 14th Amendment protects the right to privacy in the cases cited by Roe. For instance, the right to interracial marriage is protected by the 14th Amendment because choosing who you marry is an expression of ordered liberty. From there, the court claimed that if the right to privacy was protected in those cases, then the right to privacy includes a constitutional right to abortion. In the words of the court, the right to privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. However, the court asserted that this right is not absolute. At some point, the state has an interest in what they called potential life. The state has a legitimate interest in protecting underdeveloped human life after the fetus can survive outside the womb because, at that point, the fetus could have, quote, a meaningful life outside the mother's womb. It is for these reasons that the Roe Court concluded that a woman has a constitutional right to pre-viability abortions. Thank you for watching 5 Minute Ethics. Please like and subscribe.